Myself, Dr. A.N.V. Durga, Assistant Professor, Department of Commerce, P.B. Siddhartha College of Arts and Science. Today, we are going to discuss about discharge of contract and what are the various modes for discharge of contract. So, before discussing about what are the various modes for discharging from a contract, we can discuss what is the meaning of a discharge of a contract. Discharge of contract means termination of the contractual relationship between the parties to a contract. That means a contract is discharged when the obligations created by it comes to an end. A contract may be discharged by any of these following modes. Discharge by performance, by agreement, by lapse of time, by operation of law, by breach of contract, and by subsequent impossibility of performance. We can discuss all these things in detail. So, first one, discharge by performance. When both the parties of the contract are fulfilling their obligations legally, the contract is said to be discharged. A valid tender of performance is equal to performance. For example, if A promises to B that he will supply 50,000 worth goods to B. In return, the B promises to pay 50,000 rupees. A performs his respective obligation by supplying goods, and B also performs his respective obligation by paying cash. That means both the parties have discharged from this contract by performing it. Next one, discharge by agreement. Contract is the result of an agreement between the parties. Similarly, the contract may also be discharged by agreement between the parties. These are the various types of discharge by agreement: novation, alteration, rescission, remission, waiver, accord, and satisfaction. So, what is meant by novation? Novation is when the parties to the contract agrees to substitute the existing contract with a new one. Hence, the parties to the contract decide to discharge the old existing contract between them by forming a new one. Novation, therefore, may take either any of these two forms: substitution of a contract with new terms for an old contract between the same parties. That means the parties remains the same, but the terms of the contract may change. Second one, substitution of a new party for an old one, the contract remaining the same. Promisee will now look to the third party for the performance of the contract. Second one, alteration. One or more terms of the contract are changed. It is called alteration. Alteration made by the mutual consent of the parties only will be valid. The parties cannot be changed. Only terms have to be changed. Next one, rescission. Rescission means cancellation. When the terms of the contract is cancelled, it is called total rescission. When only some of the terms is cancelled, it is called partial rescission. A contract can be resigned in any of the following ways: by mutual consent between the parties or by the aggrieved party. Aggrieved party means the party who suffered the loss because of this cancellation, or by the party whose consent is not free. He can also be eligible to resign the contract. Next one, remission. Remission means concession or exemption. It means accepting lesser amount instead of actual amount. Next one, waiver. Waiver means giving up rights. When the party gives up his rights, the contract is said to be discharged. Next one, accord and satisfaction. Accepting any other consideration than the performance originally agreed is known as accord and satisfaction. Next, discharge by lapse of time. Generally, every contract must be performed within a specified time. When the time limit is not fixed for the performance, it must be performed within a reasonable time. When the contract is not performed within the time, it is treated as lapse of time and the contract is said to be discharged. Discharge by operation of law. Generally, some contracts may be discharged by operation of law. They are as follows: death of a party, insolvency, unauthorized material alteration, merger. Death of a party. In contracts where personal skills or ability is invalid, death of the party terminates the contract. In other cases, the rights and liabilities of the deceased person will pass on to his legal representatives. Next one, insolvency. The insolvency of the party discharges the contract. He cannot liable afterwards, even he earned some estate. Unauthorized material alterations. Any change of important conditions in the contract is called material alteration without the consent of the other party. The material alteration is done to discharge the contract. Merger. When the inferior rights of a person in a contract are clubbed with superior rights, then it will be known as merger. Due to this, the inferior rights contract is said to be discharged. Discharge by breach of contract. Failure of a party to perform his respective obligation under the contract is known as breach. It leads to discharge of the contract. Breach may be of two types: actual breach and anticipatory breach. Actual breach means actual breach of contract takes place at the time of actually or performing the contract. Anticipatory breach means anticipatory breach of contract takes place before due date of the performance of the contract. Discharge by impossibility of performance. If the agreement or the contract becomes impossible to perform due to some reasons which are not within the control, known as supervening impossibility, then such a contract gets discharged and all the rights and obligations of the parties to such a contract also tend to terminate. It may be of any of these types: impossibility known to the parties at the time of making the contract, or impossibility unknown to the parties at the time of making of the contract, and impossibility which arises subsequently to the formation of the contract. It may arise due to the following reasons: by the destruction of the subject matter and by the non-existence of a state of things necessary for the performance. Thank you.